Well, now we're shifting gears a little bit. We've covered some history. We had a quick look at sort of the emergence of freedom and individual liberty, which is actually a relatively modern thing. There's traces of it that you can trace back. But in the expression that we have it today, it's a relatively modern thing. One of the most exciting expressions today is, of course, Javier Milei in Argentina. We've talked about that. We've talked about Australia and what can Australia do? What should we be doing? What lessons can we learn from Argentina and what should we be doing to make Australia better? And then we finished on what I'll admit is a little bit of a down note, some of the challenges that lie before us. So as we move into this next session, I want to talk about some of the solutions. But before we get to specific solutions, we have to understand the principles that we're building on. And I know no one better to discuss the foundational principle of the rule of law, what it actually even means. We use this phrase, the rule of law. What does that mean? What is that? I know no one better than Professor Augusto Zimmermann. Now, it's not just me that thinks he's pretty good on this stuff. He is a constitutional law expert in both Australia and Brazil, which I think means two different languages as well. So you're a constitutional expert in multiple languages on multiple continents. He's the former West Australian Law Reform Commissioner. You don't get that job if you're a mug. You get that job if you know something, if you know a thing or two. And so it gives me enormous pleasure to introduce Professor Augusto Zimmermann to talk about the rule of law.
Thank you very much. It's, I don't think I can have a place to put this thing. It's, no, I think it's better for you to get it. Thank you. Look, it's a privilege to be here. Topher is a great man and he did a fantastic job. I have written, indeed, some articles about Argentina, by the way. And they are published in the Epoch Times and Quadrant. And what I must say is that when the Pope was elected, someone asked me my opinions, and I said in those days that nothing good could come from Argentina, as a good Brazilian would say that. But now I have to change my approach because Milei really gives hope to that people, to those Argentinians. And I must say that he got more popular by criticizing the Pope, which is actually very interesting. The Pope's not very popular over there. But the topic of my presentation is not about Milei. It's about the rule of law. And I decided to make it a more didactic one, more easy to navigate one. So I have a couple of slides to explain the subject of my PhD thesis, by the way. The PhD was on meta-legal reasons or elements for the realization of the rule of law. Basically to say that the rule of law is not just about having good law. We need to have a good society even. John Adams, when he was asked about the Constitution of the United States, he was very clear to say that it requires a righteous people. So the rule of law requires people who have a commitment to what I have described in my PhD thesis as the people who embrace a culture of legality. So what is after all, what the rule of law after all is? So, although the meaning is always debatable, there is a consensus here that the rule of law is indeed about protecting individuals from unpredictable and arbitrary interference with their vital interests. There are many different conceptions of the rule of law. We could divide them basically into two camps. The substantive conception of the rule of law, which is about reminding us that the law has something in relation to protecting fundamental rights and freedoms, in particular the rights to life, liberty, and property, and those who think the rule of law is more about certain desirable elements regarding a recipe for legal institutional design. but the rule of law is above all a solution to what we would describe more commonly in the past, a solution to the problem of political tyranny. And this statement comes from John Locke, that the rule of law is about avoiding governments to destroy, enslave, enslave or destroy, enslave, or impoverish the citizens. So this is pretty much connected with the idea of the rule of law protecting our fundamental rights and freedoms, rights to life, liberty, and property. It implies that government acts through laws, and these laws will not just be enacted to serve the interests of government, but it will be for the protection of our basic rights. So the idea is intrinsically related to a classical liberal tradition of constitutional government and protection of individual rights. And some of my colleagues in the legal profession, they tend to associate the concept of the rule of law with the teachings of Alfred Dicey in the 19th century, because apparently he would have coined the phrase the rule of law. But I think we should go much back in history and actually go to the 13th century and have a look at Henry de Bracton, who is considered to be the founder of the common law or the father of the common law, because he was the first to write a comprehensive treatment of the common law as a legal system. And that's why his book, De Legibus and Constitutionibus Anglia, is considered to be so important, because it was the first systematic treatment of the common law. So that's why he earned, and I could say quite meritoriously, the title of the father of the common law. And in this book you find statements such as this: the king is under God and the law, because the law makes the king, for there is no king where will rules rather than the law. And this is an important statement because it was used, for instance, by Sir Edward Coke in his interactions, not very pleasant interactions with James I, who thought that he epitomized the law. He thought that being the king, he could do pretty much whatever he wished. And Coke had to remind him that according to the legal system in place, he was to be subject to the law and not just the personification of the law as he expected to be. That cost Cook's job, by the way. He was fired for having this assumption. But that was, I don't think, a good thing for the king to do. His son actually lost his head in the process. And Cook became a member of parliament. You know, as people say, the rest is history. Basically, the struggle became more one between the parliament and the king. But just to make sure that I'm not making this up, this is a statement coming from Sir Owen Hood Phillips, and he's indeed considered by many to be the leading constitutional law professor in England of the 20th century. And then he says this: historically, the phrase rule of law was used with reference to a belief in the existence of law possessing higher authority, whether divine or natural, than that of the law promulgated by human rulers, which imposed limits on their power. Bracton, writing in the 13th century, adopted the theory generally held in the Middle Ages that the king himself ought not be subject to men, but subject to God and to the law, because the law makes him king. The same view is also expressed in the year of the books of the 14th and 15th centuries. Such superior law governed the kings as well as the subjects and set limits to the prerogative, which is the royal power. On that ground, John Fortescue, in the middle of the 15th century, based his argument that there could be no taxation without representation. You know, this is one of the leading causes of the American insurrection in the 18th century, when on the basis of this principle, they thought it would be necessary to separate themselves from England. But this is John Fortescue. Look, he looks really handsome in this photo. He was the Chief Justice of the King's Bench, and his Laudibus Langum Anglia is deemed as a masterly vindication of the laws of England. If Bracton, I can say, is the father of the common law, Fortescue could be considered the father of English constitutional law, because he wrote the first comprehensive treatment of the English Constitution. And what he says, amongst other things, of course I have only 30 minutes, I have to be really brief, but this is one of the subjects of my teachings as a legal theorist. I used to spend hours talking about him, but basically this passage here is quite important. He says that England is a constitutional monarchy because the King of England is not able to change the laws of his kingdom at pleasure. For he rules his people with a government not only regal, but also political. So these are the terms used in those days, but basically what he means by that is the fact that England didn't have a king that was an arbitrary ruler, an absolute monarch. And we could use this idea of England being a constitutional monarchy. That's why he calls political. And this is my favorite sentence. I absolutely love it, because it tells you that in the common law tradition, the idea of freedom is considered to be essential. And it's considered even to be any law which violates this idea of freedom, a fake law or a defective law. And he quotes quite often, quoting here from Aquinas, when he says that bad law is no law at all. It's actually a defective one. So if the law doesn't advance liberty, it's actually a defective one, and the governments behave in a tyrannical way. St. Augustine actually distinguished between a decent, proper government and a bunch of criminals, making this fine consideration that the laws must always aim liberty and the common good. And if it does the opposite, the law being an instrument of oppression, the distinction between a gang of criminals and the proper government ceases to exist. And then he says this: a law is necessarily judged cruel if it increases servitude and diminishes freedom, from which human nature always craves. For servitude was introduced by men for vicious purposes, but freedom was instilled into human nature by God. Hence, freedom taken away from man always desires to return, as is the case when natural liberty is denied. So he who does not favor liberty is to be deemed impious and cruel. He considered these matters as laws of England, and he put favor, the laws of England. It should favor. It's no longer the case, but it should favor liberty in every case. Another important person here is Sir Edward Coke. One interesting aspect of Fortescue's work is that even though he was sort of pioneering constitutional law, English constitutional law, he actually didn't know the Magna Carta even. The Magna Carta was forgotten for centuries. It was basically resurrected by Coke. And Coke turned the Magna Carta into pretty much a Whig or classical liberal document. And he's called the Shakespeare of the common law. So he famously quoted from Bracton, reminded the king that he must be under God and the law. And he created also what we now describe as judicial review over, I would say, unconstitutional law. And he did so in this case. I cannot elaborate on this, we don't have time. Unfortunately, it's only 10 minutes remaining. But he says, and it appears in our books that in many cases the common law will control acts of parliament, and sometimes adjudge them to be utterly void. For when an act of parliament is against common right and reason, or repugnant, or impossible to be performed, the common law will control it and adjudge such act to be void. That's the genesis of the idea of judicial review over unconstitutional law. And John Locke gives us a remedy as to what needs to be done if the government acts in such a tyrannical manner. And he uses a proper jurisprudence to say that you have the right to lawfully resist. His work played a fundamental role in the development of constitutionalism. Locke's work provided philosophical justification for the Glorious Revolution. And then later on, he is the real drafter, spiritually speaking, if I can put in such manner, of the American Declaration of Independence. We could even accuse Thomas Jefferson of having plagiarized Locke. I'm kidding, but basically it's like, if you want to know what Locke has to say, the American Declaration of Independence is the way to start. And he says this: the end of law is not to abolish or restrain, but to preserve and enlarge freedom. For in our states of created beings capable of laws, where there is no law, there is no freedom. For liberty is to be free from restraint, and violence for others, which cannot be where there is no law. And if the government dares to do the opposite, it ceases to have a proper legitimacy, because the positive laws of the state, they are placed under this hierarchy, whereby the most important law is the natural law, the law of God. So a government that violates this natural order, it ceases to have legitimacy, and you have to revolt, to rebel, by lawful means even. And he says this in his chapter 19 of his second treatise, that whenever the legislators endeavor to take away and destroy the property of the people, he means their rights to life, liberty, and property, or to reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any further obedience, and are left the common refuge which God has provided for all men against force and violence. So this is the lawful justification for violent means, by violent means, if necessary, if the government acts in an intolerable fashion. So what follows are a few essential elements leading to the realization of the rule of law. So I could say, for instance, the laws must apply generality. So we should not have laws directing themselves, these laws, to one single person. You know that in WA they did this very thing with Clive Palmer, and that is in American constitutional law explicitly forbidden. In our common law tradition, it's also explicitly forbidden, but the American Constitution says that this is unconstitutional because this is called a bill of attainder. And I can explain one day in further details what it means, but basically laws should not target individuals. They should be general laws that would be applied to all sorts of peoples. Laws should be as stable as possible, meaning that stability of law allows that we can know the law and can predict our actions or plan our actions on the basis of what we see in the law books. We can plan our lives and can have our lives basically controlled by us. So the aim of stability is to facilitate personal planning and a fruitful interaction among fellow citizens. Certainly, we didn't have any stability of the laws during the pandemic, or plandemic, as some people say, when you notice very clearly here that the laws were changed at the pleasure of a small oligarchy. Another thing connected to this, that the laws should limit, control, and guide the exercise of government power. The conduct of government officials must be regulated by clear, stable legal rules that control, guide, and limit the exercise of power. So emergency powers are a clear example of violation of the rule of law. It's always used as an excuse, emergencies, to pave the way to dictatorial regimes. I mean, I think it seems that lack of history can cost us very dearly, because that's how all dictatorships, tyrannical regimes start. They always create a crisis. They always create fear. Hitler did such a thing. All tyrants never tell you that they are going to be tyrannical. They always come with an excuse to become tyrannical. So the use of emergency powers Every despotic endeavor requires popular acquiescence. So scaring the population is a good strategy. And Hayek says that this is a common strategy. And he says that the conditions, that's found in his book, Law, Legislation, and Liberty, the conditions under which emergency powers may be granted without creating the danger that they will be retained when the absolute necessary excuse has passed are among the most difficult and important points the Constitution must decide. Emergencies have always been the pretext on which the safeguards of individual liberty have been eroded. And once they are suspended, it's not difficult for anyone who has assumed such emergency powers to see to it that the emergency will persist. Montesquieu, talking about despotic government, says that that's pretty much a government based on fear. So one way that despotic government can be manifested is via the lack of proper separation of powers. And that's exactly what takes place because Suryaratnapala, a constitutional law professor, explains, and I quote now from him, that the rule against the delegation of wide lawmaking power to the executive is a major component of the classical doctrine of separation of powers. When officials can both legislate and execute their legislation, they have the potential to place themselves above the law, for the law is what they command. So we need to have separation of powers as an important element for the realization of the rule of law. So another element for the realization of the rule of law, the courts must be independent, impartial, and accessible to everyone. I don't think this is actually necessarily the case in Australia because even judicial appointments are of a political nature in Australia. I was appointed a commissioner, you mentioned this fact, when I was the vice president of the Liberal Party in my division. I think there might be a connection with that. So I think that's the way, unfortunately, they are appointing members of the judiciary as well. So the rule of law is a meta-legal doctrine. This is based on my PhD thesis, saying that this is related to conditions of liberty. But the population must want to be free. If they have the mindset of slaves, the rule of law is not going to be considered to be good for them. The rule of law is about a common ideal shared, unquestionably accepted by the majority. The rule of law will not prevail unless it forms part of the moral tradition of the community. Unfortunately, I cannot read what Hayek says. I don't have time. It's a pity. In other words, the rule of law depends as much on social, cultural, political characteristics of society as of the laws and the interactions between these extra-legal elements and the legal institutional ones. So another thing you have to bear in mind is that having law doesn't mean being under the rule of law, because the laws can be used, and they have been used, especially over the last years in Australia, as instrument of oppression. And so it's important to bear in mind what Professor Mortimer Sellers said in this statement. Positive laws may sometimes be an advance on otherwise unregulated tyranny. Promulgations and other virtues of legal formalism often advance the empire of laws, but they are only secondary and contingent to the requirements of the rule of law. So Constitution is a derivative of the rule of law, and Suryaratnapala is saying that it's pretty much connected with the enjoyment of stability to life, liberty, and property, once again referring to the assumptions of John Locke. Even the French got it right in the very beginning of the revolution. Then you know that everything went very badly over there. But they say that a society where there is no protection of individual rights and separation of powers do not have a constitution. So we just wonder whether Australia still has one, because that's not happening at all. Thomas Cooley, the most prominent American constitutional law professor of the 19th century, said pretty much the same. You need to have protection of individual rights and restraints on exercise of political power. So, because power corrupts, said Lord Acton, and absolute power tends to corrupt absolutely. To prevent this abuse, it's necessary that we should separate powers. And Ivor Jennings was one of the best legal minds of England in the past century. He says that all power is likely to be abused unless it's adequately checked. One thing, this is a statement from the Baron de Montesquieu, just explaining the need for separating the legislative from the executive, and I think this is becoming each day more visible and prominent in Australia because you do not have and have never had proper separation between the executive and the legislative branches. So a proper separation would work like this, but I don't have time to further elaborate. You can perhaps have access to these slides later. So there is no separation of powers in Australia. The Westminster system is a parliamentary system originally developed in the United Kingdom, and this results in the leader of parliament, the prime minister or premier, controlling the executive branch and even appointing chief health advisors as they did in Queensland, and a vaccine commander in Western Australia to be our governor. So Nicholas Arone is saying that under contemporary conditions of parliamentary government, there is a tendency for both executive and legislative power to be concentrated in a very small group of oligarchs. Oh, sorry, senior minister. I thought he was saying oligarchs. Sorry for that. So as for the heads of state, governor general and governor, they are appointed by the king on the advice of the prime minister or the premier. But who does the governor general or the governor really represent in this day and age? Well, you have to think twice if you think that is actually representing anything but the interests of the oligarchs. Because the chief health advisor was appointed to be governor in Queensland, whereas in Western Australia, a terrible oppressor, the police, that at least tells us that we have a police state, because the police commissioner is our governor, and he was also called the vaccine commander, basically declaring war on the recalcitrant. To make it worse, the courts have chosen to not draw a line in the sand against excessive delegation. So one thing that's happening now is that they are transferring legislative powers to the executive. And Suryaratnapala says that the High Court is the main culprit that has allowed the executive to have legislative power. And Sir Harry Gibbs confirms this fact, former Chief Justice, saying there is no constitutional impediment to the exercise by one branch of government of the powers of another. This basically means that in Australia, Parliament may repose in the executive a function that is legislative in nature. It's indeed difficult to reconcile these decisions with an acceptance of the principle of separation of powers, said Sir Harry Gibbs. So another problem that I see, I have 1 minute at least, thank you. Parliament is competent to make any law or any matter whatsoever. In other words, no right, no individual right can be deemed fundamental. We got this terrible idea from England, it's called the doctrine of parliamentary sovereignty, which is not compatible with a proper realization of the rule of law. So Owen Phillips says in his book, there are under the Constitution of the United Kingdom no rights strictly fundamental in the sense of entrenched, basic, inalienable because of the supremacy of Parliament. And so others would agree with him. I'm referring here to very important judges. They would say pretty much the same. I don't have time to read these statements, but they would confirm this terrible assumption. So in other words, under parliamentary sovereignty, no judicial body can question the validity of an act on grounds of its violation of fundamental legal rights. This serious problem in our constitutional framework was also confirmed by the late Lord Justice of England, Tom Bingham. I don't have time. So it's no wonder, therefore, that so many of our most basic rights and freedoms can be so easily ignored and violated. What we have in Australia, and the English had the British people, the United Kingdom has experienced, is an elective dictatorship. What we have is an elective dictatorship. And I could go with further statements, but the lack of time doesn't allow. So to conclude, there is no separation of powers in Australia at all. Our constitution never have been so good, in my opinion. In my opinion, a constitution can only work if we think about what John Adams said about having people who are righteous and self-restrained, because there is no proper constitutional framework that can resist a nation populated by slaves and people who do not have any sense at all of self-respect and dignity. And that's the main problem that you have in Australia. It's not just so much undergoing through, we could consider to be a constitutional reform, but it's to change minds and hearts and make people love and appreciate a little bit more their rights and freedoms that they have ceased to have at this point. So the Australian courts aggravate the problem by allowing the executive to legislate via delegated legislation, thus further undermining separation of powers. And not even our judges are fully independent, because they are always invariably appointed by the government of the day. This appalling lack of checks and balances naturally facilitates human rights violations via a vast concentration of powers in the hands of a few. In some, indeed, Australia is an elective dictatorship. I don't consider a country, I don't consider anymore, a nation under the rule of law. It's time to bring back the rule of law. We have to bring back the rule of law because this is something we have ceased to have. And Professor Gabriel Moines and I have written an article, many chapters about what I'm saying here. Aspects or elements of my talk today are found in this book, Foundations of the Australian Legal System. I have, together with Professor Moines and Joshua Forrest, written books such as Emergency Powers, COVID-19 Restrictions and Mandatory Vaccination, providing a rule of law perspective, and this book called Fundamental Rights in the Age of COVID. And I also have recently written another book with Professor Gabriel Moines called The Unlucky Country, which is our latest understanding of this terrible predicament. And copies of the book are available. We have only a few. But it's basically to tell you that Professor Gabriel Moines, the leading constitutional law professor in this nation, is very, very upset because our area is being under attack. And I do not want to lose my job, but I do not want to actually fail you. The price of liberty is indeed eternal vigilance. And I'm not going to be silent. I promise you that I'll continue to fight. Thank you very much. Thank you. Thank you.